The Honorable Deputy Speaker.
Honourable members, as we resume after tea, I will recognize the member for Naparima.
Thank you.
You have 22 minutes, 13 seconds of your initial time.
Thank you very much, Mr. Deputy Speaker. When we adjourned, I was looking at clause 13.1 of the bill and indicating that this clause reposits too much power in the hands of the authority, and therefore the approach of the bill was control over rather than collaboration with the security firms. If we look at 13.1 of the bill, the functions of the authority are to establish guidelines, establish standards to the purpose of this act, regulate the private industry, and ensure compliance with this act. Annually review the licensing regime, and the question came about whether it was automatic or whether it was a situation as if you were starting afresh. Issue, revoke, suspend, cancel, and vary licenses. The language is harsh and oppressive, Mr. Deputy Speaker. Establish training and practical standards for certification of the security officers, and establish and maintain a register of all licensees. When we left as talking about the Irish approach to how they deal with the regulation of the security services in that jurisdiction, and the concern of the business people who are the security firms is that the functions and powers of the authority it appears to seize ownership and the rights of the owner. And when we looked at the Irish Private Security Act of 2004, there are three broad areas: ensuring that security officers are licensed to perform duties of the security. And licensing, the regime started with entry qualifications, training, updating of training, output skills, etc. Ensuring that the licensing regime, establishing a regimen of training and adjudication to training for persons seeking to qualify to work within the industry. So one would have hoped that there would be some kind of qualification, some collaboration with an institution like COSTAT to develop very basic participation courses to certify the security officers, so that we will have an upgrade of the skills and competencies in the industry. Establish a system of investigation and adjudication to treat with complaints of the licensees. The Irish Act promotes an authority that works in harmony with the security industry. This local bill, and I'm just repeating the concerns of the security industry, security firms. This local bill does not do that, but rather suggests a big stick approach, which raises questions relating to the confidentiality of the licensees. Mr. Deputy Speaker, we see in a section, in another section, the fact that the authority is required to maintain permanent records of the character, etc., of the workers, of security guards. And we talk about permanent records. It means that if you have an illness, if you have a drug problem, this will be in the repository of the authority forever. And one would want to look at, and the Joint Select Committee could look at, whether they would want to put some time frame on that. But one of the concerns,
6 years?
6 years, 10 years, whatever, but it cannot be that if I joined something at 18 years, that some institution is going to have a permanent record, and I could be judged by that forever. Good.
Member.
Yes. Yeah.
Are you, in making that suggestion, which on the face of it appears appealing, but are you mindful that in this world and in this time of terrorist activity, that cells could lay low for 10 years and then take the opportunity to make a big strike?
Yeah. I appreciate your point, Member for Laventille West, but are you also aware that in first world jurisdiction, there's a whole tendency towards rehabilitation, so that after a specified period, the slate is wiped clean and you are allowed to start afresh. And therefore, no, we could, those things.
Thank you very much. I appreciate that. We're not talking about a criminal conviction, you know. We're talking about the records of the individual, all of them. In the public service, you join at age 18 and they keep it until after you are gone.
Okay, thank you very much. So that if in the States, and in Canada, if you have a drug charge when you're 18, after a specified period, the same thing that the records are held here permanently. We are not saying not, but perhaps not all, but certain categories could be for a shorter period. But with reference to clause 13.5, the Irish Act promotes harmony and consultation, and there's a whole study, an area of study of how the private security firms can work with the state police service in order to have that level of complementarity, so that they could you could take advantage of the best practices in both areas. But the concern of some of the firms is that this authority, an extension of the executive, is putting too much control. One must ask also whether one of the functions of the authority is to promote a private security industry that is characterized by professionalism, transparency, accountability, equity, and accessibility, and whether the government is in its practice will promote an authority that is similar in nature. They are concerned about favoritism and that this information somehow could be used to their disadvantage. They have noted and they have said that there seems to be favoritism in the advertisements, etc., with respect to private security firms. They talk about a favored security firm, and I'm quoting, this private security firm now controls the health sector and security at all our ports of entry, land, sea, and air. And they are firmly entrenched in the financial sector, moving large sums of money for the government. They have a monopoly in the movement of prisoners, and they have virtually taken over the oil sector. So I'm just saying that if we are to promote the development of entrepreneurs in our society, independent people of wealth, the government must be a facilitator, and it must appear to all in the sector that it is fair and they stand an equal chance. When I started, I spoke about the persons who characterize the industry and my concern for them. Mr. Deputy Speaker, 2 weeks ago, we heard about the horrific death of Jeron Ferdinand, who was found bound and gagged with a single gunshot to his head on a cargo vessel anchored off the port. Reports are that he was assigned to the vessel after a robbery took place there last month. And I got that from The Guardian, May 22nd, 2019. We heard about this incident of this young gentleman who was looking to survive, took the security job, and was assigned clearly in a danger spot. Questions remain as to why he was killed and what compensation his family is entitled to compared to the $1 million that police officers get if they die in the line of active duty. We need to have some, not necessarily $1 million, but we need to have some concern, because we are talking here about a disadvantaged sector in our society, a demographic in our society. What training was he given? Were his employers aware that they were putting him in a potentially dangerous situation? And I heard the member for Laventille West allude to a training program, and I thought I was transformed elsewhere, because like the member for Oropuchis, I read this bill 5 times. And I did not see the kinds of things that he was talking about in terms of a pension plan, etc. Maybe that is the intent, and it is something that we will support when we get to the Joint Select Committee. Did he work in a company which this government owed millions of dollars? and had to scringe on wages, training of staff, and support systems in order to survive. That is a reality, that the system is on the verge of collapse because of the fact that the government is negligent in paying its bills to these organizations. On the 15th of April 2019, another security guard, 57-year-old Roger Boreal, was found in Chagaramas. They found him lying in a pool of blood on the ground. He had a gunshot wound to his head. I'm only saying these things to give you an idea of the problem we face and the need for the legislation to remedy the problems. No, it is no use for us in this ivory tower to sit down and say, pass a bill that does not bear any semblance to the reality on the ground. On June the 2nd, 2019, 2 security guards who refused to allow a group to enter a private pool party were shot by the 2 men from the same group. According to police security officers, Franklin Boris was shot in the left leg, while his colleague Al Sandiford was shot in his right foot. Mr. Deputy Speaker, in an industry that is 65% female, what is being done to ensure that our female security officers are also protected? The president of the Estate Police Association, Derek Richardson, said, and I quote, "There are also women issues. Sometimes they have to use male bathrooms." According to recent statistics, as much as 65% of the industry is female, who often work longer shifts in order to make enough money to survive. Now, if they cannot take care of their children, and their children are left with relatives or strangers or whatnot, particularly when they have to do a double shift, we need to do studies to find out whether the children of female security guards, whether they are single parent, whether they are at risk, and therefore the society and the country needs to make some intervention in order to help that situation. I quote, "A lot of women are made to work these long hours to make up the money, and the social fabric, the family unit, is being eroded as a result of these long absences." And he says it's inhumane, it's cruel, and it borders on criminality. That is what we face. That is what we have to correct here. We cannot regulate a sector and leave them vulnerable and hope that if you register, if they're licensed, that all these problems will go away. It has to be articulated with specificity in the legislation. In The Guardian, reported on the 3rd of February 29, that, and I quote, "Sexual predators, bandits, and trespassers are creating fear among female security guards of the National Maintenance, Training, and Security Company. The security guards affected are those dispatched to 5 primary schools in Maracas, St. Joseph area, and work 12-hour shifts from 6 a.m. to 6 p.m. and from 6 p.m. to 6 a.m. Recently, there was an attempted rape. The woman was said to be so scared that most times, when she's working a night shift, a relative or friend is present with her on the job to provide added security. That is what we face. That is what our security officers face. They are victims of robbery, physical abuse, and recently some murdered in the process. Now, the question of how can we move from that situation to something that is better? Part of it has to do with representation. But the Estate Police Association laments that in order to operate efficiently, the association must be able to represent all officers under current laws. The EPA is unable to represent security officers who are not members of the association. Reported in the newspaper, the president shared a photo of on social media showing a galvanized hut in South Trinidad, which was allegedly used to shelter security officers. And it quotes, "This is a security booth behind Pizza Hut in Gulf City. Galvanized hut, not fit for a dog, but a security officer, it's good." I think my friend spoke about the dog, the food that the dog got was superior to the food that the security officer got. You see, as we talk, as we move into a society where we want to lessen income inequality, we want to have more equality, we want to have a system where everybody in this country has a fighting chance. Every bit of legislation that we bring to this floor must take into consideration the concerns of the disadvantaged in our society. He said, on visiting the site, he observed a tiny shed held 4 chairs, implying that as many as 4 human beings were forced to stay and work in that hut. We have been saying, and he says, we have been saying that the security industry is an environment where officers are made to work long hours in inhuman conditions. We have decided to highlight these areas where security officers are faced with working as much as 48 hours at a time, and many times they are not being paid for an overtime rate. This is oppressive, this is unkind, this is an embarrassment to a society that aspires to be a first world country. I'll now go to specific problems I have with the bill. Clause 13.3 says, the minister may give general policy directions in writing to the authority, which the authority shall follow in the performance of its functions or exercise of its powers under this act. Mr. Deputy Speaker, this enables the minister to give general policy decisions in writing to the authority, which must follow. The potential for political mischief or favoritism exists. What is the point of having such strict requirements for the composition of the board and stress the independence of members if the minister has such great influence? Respectfully, this clause needs reconsideration. I would not necessarily say be it removed. The minister already is afforded the power under this bill to amend section Schedule 1, 2, and 4 by order, and everything else should come before Parliament or be decided by the board. Clause 82A empowers the minister to make regulations in relation to uniforms, authorized insignia, and other equipment to be worn or used by security officers. Why is the minister becoming involved in marketing and essentially branding of private security firms? And these regulations are subject to negative resolution. We have said, and we always say, let it come for affirmative resolution where we can debate and treat with the changes that the minister makes. Clause 24. The board is entitled to employ and remunerate as many people as it sees fit and put a pension plan in place for the employees. Now, I think this is where the member for Lavantil got confused, because the bill speaks of a pension plan for employees of the authority, not the workers, the security officers, which on our side is the main concern. The main concern. So the board has, in its own right, is entitled to employ and remunerate as many people as it sees fit and put a pension plan in place for its employees. This has the potential to create mischief again. Some oversight perhaps ought to exist to ensure that nepotism and corruption is prevented and to prevent exorbitant salaries being paid. Mr. Deputy Speaker, I say that we just had last week the instance of Carl Jagdeo, the case of a CPEP CEO who was paid $1 million gratuity after having held the position for 1 year. So, Deputy Speaker, I have worked 19 years in NP at a senior management level, marketing manager. And when I left that organization, I did not see anything close to $1 million. Something is happening. And if we are confronted with problems, and we ignore them and we get on as if nothing has changed, we create the problems and it becomes manifested. We need a mechanism in place to ensure that the board doesn't run out on a frolic of its own with all this power over 50,000 workers and 500 security firms, and they begin to pay themselves exorbitant salaries. Clause 27, the employment of inspectors. The bill merely states that the individual must be the holder of a precept. The consensus is these inspectors wield great power and ought to be hired on the basis of much stringent qualifications. You cannot take somebody whose only qualification is being a precepted officer and put him as an inspector to enter into firms, demand information, right? And if you do not provide the information, you are subject to significant penalties. Perhaps some background in law enforcement or compliance would be desirable in order to maintain the integrity of the position, as there is a potential to negatively affect the security operator's business if the inspectors fall below standard. Not only that, we are talking about a business where there's a lot of migration. People leave one firm and go to another firm. They get fired. They end up as inspectors. They hold grievances against particular firms, wielding that amount of power without a warrant, going into organization and demanding information and could take things. That is madness. The problem is, we even had a problem in San Fernando where people went with warrants on the basis of San Fernando West, on the basis of information that subsequently was found to be very tenuous. And that was with a warrant. And you are given an inspector whose only qualification is a precepted officer. And he could walk into an organization and demand information and take away equipment, etc. That is madness. And that is why the security firms are talking, what is this government? Why is this penchant for power? Why? We are in a society, and the same thing we get here, Mr. Deputy Speaker, the insults, right? The sense that you don't belong, that somehow you are persona non grata. It is the same characteristic that extends to all the legislation. And they treat the security firms with that scant disregard. And all of them have said were not consulted. The association was not consulted. How you could make legislation in no self-respecting democracy in the world? Would a government be brave enough to bring legislation to this parliament and not consult the main stakeholders in the industry? Madness, Mr. Deputy Speaker. But we on this side are accustomed to that. We are accustomed. Thank God. Thank God for the Privy Council. Thank God. Thank God. And don't bring the CCJ bill here in the Privy Council. I can tell you up front, unless we get a directive from the leader from Separia, we're not going to give up that last avenue of independence and impartiality in this country. Clause 31, Mr. Deputy Speaker, grants an immunity to inspectors performing duties in good faith. You have a man who is a precepted officer, no other qualification. He could walk in your place, take information, perhaps, hopefully if he's good. I mean, I know there are penalties in the law if he gives information and whatnot, but you know how the society operates. He could give it to your competitors. And if he does that, he has immunity if he acts in good faith, because you would not know what he has done with the information that he has received. And he maintains that information permanently. What is he thinking? Where does... Sometimes you get the impression that that there is wake up with a nice idea, there's a VAPS, but there's no thought going into the process. And when you sit back and you analyze it, it had to be madness going on. It has to be madness. Clause 29.1, the ability of inspectors to conduct random inspections on premises of security operators, proprietary security organization, has the potential to disrupt the business in an industry as hectic as security. So he walks in there and you have to just stop your business, and he parades all over the place. And if you do not pay him attention, if you do not give him information, you are subject to significant fines. Mr. Deputy Speaker, we have problems. We have problems. I was talking about some concerns I have with the bill. The first concern I had was...
Honourable Member?
Yes, sir.
Your initial speaking time has expired. You have an additional 15 minutes.
Yes.
Care to avail yourself?
Yes, sir. Thanks very much. The second major concern I have, is that this bill appears to meet one of the state's and finance minister's objectives of raising revenues even on poorly paid security officers. Refer to, I'll give you examples of the penalties. A revenue generating exercise. Here are the penalties. Clause 69 to 80 of the bill provides various offenses and penalties. Clause 69 creates an offense of obstruction of an inspector. And a person who obstructs is subject to a fine of $15,000 and to imprisonment of 2 years. That's small money. Right? So if I was struck, why you come in my place? Where's your warrant? Where's that?
Big money.
15,000, 2 years. Clause 81, sorry, clause 69 creates an offense of, 70 of the bill makes it an offense for an inspector to disclose information. And if he does, it's 30,000 and imprisonment for 5 years. Clause 71 makes it an offense for inspector to falsify his report. $30,000, 5 years. Money, Mr. Speaker. Money, Sir Deputy Speaker. Clause 72, the bill creates an offense, etc., and a person who an offense related to security service operators, namely providing false or misleading information, etc. A person who contravenes Clause 72 or fails to comply with Clause 36.8 and 36.9 commits an offense and is liable on summary conviction in the case of a body corporate to a fine of $250,000. B, a director or other officer of a body corporate a fine of $100,000 and imprisonment for 20 years. Anybody serious with this bill? C, 20 years. C, any other individual to a fine of $30,000 and imprisonment for 5 years. No, that is not all the money. There are more. This finance minister, he good. Clause 73. He will tax me for talking hard in Parliament. Sometimes when I hear the bitterness coming next door, you get the sense that if they had an opportunity, I'll be taxed for speaking in Parliament. But God is a good God. And they say in my scripture, no weapon formed against me shall prosper. I have faith, Mr. Deputy Speaker. 73, right? A person who fails to comply with clauses 41.4 and 41.5 commits an offense and is liable on summary conviction in the case of a body corporate, $250,000. A director, $100,000. Any other individual, $30,000. Right? Clause 74 creates an offense related to security officers, namely providing false or misleading information. A person who contravenes this clause commits an offense and is liable on summary conviction to a fine of $25,000 and imprisonment for 3 years. But they want to lock up everybody. They want to lock up everybody and take your money. How else security guard? We're going to get $25,000. When he operates at, or she operates at minimum wage, works out under $3,000 a month. And you're going to find that person because the person gives some false information. $25,000 and 3 years in prison. Clause 75 creates an offense related to special security officers, namely providing false information, etc. A person who contravenes this clause commits an offense and is liable on summary conviction to a fine of $25,000 and imprisonment for 3 years. You think I want to go on? It's pages and pages of fines. Pages and pages. When they talk about control, for heaven's sake, are we there to look at a situation, organize it in terms of outputs, and create something that is better? Clause 76, impersonation, $30,000. Clause 77, an offense to forge or tamper a license, etc. A security service operator, $175,000. A director, $100,000. A security officer, poor fella, he gets $3,000 a month. My pension probably higher than that. He has a fine of $30,000. And I don't have $30,000. I mean, I would like to have 23 million, but I don't have 23,000. A person other than a person referred to in para A, B, and C, a fine of 20,000. Clause 78, it makes an offense to a person to obtain or utilize a security service form, 100,000. 79, an offense to a member of the board or any service or to disclose information he receives during the performance, he has to pay 50,000 and imprisonment for 2 years. And clause 80, and all of this is money, solid, liquid, cash. Clause 80 makes it an offense to a member of the board, the CEO, or any other person attending a meeting who fails to declare his interest in any matter. He's subject to a fine of $100,000 and imprisonment for 3 years. This is essentially a money-making exercise, and it is designed in our view to be so oppressive to the small security firms that only the large ones, the financiers of the P&M, would be able to survive and prosper in this world where the economy has turned around and all of us are living like Enid Blyton, happily ever after.
Famous five.
The third characteristic is that it appears to destroy smaller security firms who are owed millions by the state. The onerous fees. Part 3, in addition to what I told you about fines, there are now fees in Part 3 of the bill. They have to pay fees. The bill says in Part 3, finance. There is to establish a fund to be known as the Private Security Service Authority Fund. Let me hide my wallet, because lock up my wallet. Because the way things are going on that side, I will leave with no money. There is established a fund to be known as the Private Security Service Authority Fund, hereinafter referred to as the fund. The fund shall consist of such sums as may be appropriated by Parliament. Cool. Monies paid to the authority by ways of fees collected under this act. Mr. Deputy Speaker, the humble poor security guard, if he wants a license, and if the firm, and in fact if he works for a proprietary firm, the onus is on him to get the license. So he has to go and pay for the license, to give fees, to provide for high wages for the friends and family, what they say, the 5 Fs, the friends and family and financiers, to enjoy the hard work of the poor and lowly citizens of my country. Clause 29(4) stipulates that police officers may accompany inspectors. Perhaps where 29(1) is concerned, it should include an officer must, not may, must accompany the inspector. And a written list of items removed, requisition, must be provided to the authority and also the security company. Clause 29(4). The ability of police to accompany inspectors. The circumstances ought to be specified. It cannot be you wake up a morning, catch a vaps, and decide you're going into this firm and not that one. You don't give notice. We are talking about specifying the situations in which you can make an investigation into a company. Don't mix the two. We're not the P&Ms. Right? Anyhow, clause 44(3). Companies are required to apply for registration for each security officer and pay a prescribed fee for this license. Additionally, applicants are required to undertake a drug test to be conducted by a state-appointed laboratory. This creates additional expenses for the company. It's already practice. It is already standard practice for companies to drug test new recruits. The major companies have EMTs on staff who can perform these drug tests, and the authority can do random drug tests in order to ensure that the standards are being utilized. We are talking about the situation where you have 3,000, the large firms, 3,500 security officers. And if every year you have to do a drug test, it works out to 300, 12, 36, 300 drug tests you have to pay for in order to remain compliant. Now, age discrimination, and I understand age discrimination, clause 47, one individual 65 years or over is issued with a security officer's license. It's only valid for 1 year. And the question is, is this discriminatory against persons of my age? I am 70 years old and much healthier than many on that side of a much younger age. It would have been better if you said he has to be healthy and able to do the job. In the United States, you're finding out, for example, that retirement age in Trinidad is 60. In the United States, it's 66. And when we were at the UN, the employees had an option. The US employees in the mission had an option to leave at 66 or 60. In Trinidad, we do not have that option. Throw them out. You're old. Forget you. Go through. You're stupid. 72(7).
Member, the last word.
All right, I withdraw it. I withdraw. states the potential liability that a company can face for non-compliance with clauses 36, 8, and 9, which deal with the need to report HR activities in the authority within 7 days. So if you have a HR officer who falls down on the job, the organization is charged $250,000 for failure to comply.
Which clause you on, member?
I am on clause 36.8, 36.9, 72.7, and 73.2. And that speaks about the administrative error and the requirement to report. Handling a dog without a completed required training course. Now, I read the dog act, the dangerous dog act. And I was trying to find out, do we have a certified, I don't know, but you could tell me whether we have a certified training course for dog handlers in Trinidad and Tobago. We may have. I don't know, and I could be advised. You see, we put training and whatnot, but we don't have the standards. Clause 74.3. A security officer shall not handle a dog unless he has attended and successfully completed a course of training in the control of dogs as recognized by the minister, etc. Okay.
Silence, please, on the government side.
The general feeling emanating from the bill in its current form is that it heavily favors major security providers and will likely cause the smaller companies to sell or foreclose. And the question I ask to the members opposite is, why do you favor the large organizations and not the small businessman?
Remember, you have 2 more minutes.
When I was a P&M in those days, when I was a P&M, and the Lord will forgive me for that. The Lord will forgive me. It was always, the emphasis was on the small man. But today, they have changed. All their actions are due to the benefit of the bigger companies. The bill creates new expenses for security providers. More structured consultations are necessary. More inclusion of the Estate Police Association in the process. You all are not P&M. In the old Eric William days, you are not going to make that. I maintain that this bill favors one company more than any other. In Kenya, the chairperson must be a citizen of the country. Maybe we need to look at that, particularly in the context of the fact that CARICOM nations can come to Trinidad. Okay, CARICOM, but suppose the Americans want to come and establish security services in Trinidad, we need to specify that. In the UK, the authority can make recommendations for the maintenance and the improvement of the security industry. We see regulation, we see control, we do not see mechanisms for improvement in the industry in our situation. Conclusions. There is work to be done on this bill to improve its practicality and applicability to the existing industry. The authority ought to be held to a higher standard of accountability, and as such, the bill should state more defined rules and functions of the authority. So, Deputy Speaker, the relationship between the TTPS and the authority ought to be specified. Thank you, sir.
Recognize the Attorney General.
Thank you, Mr. Deputy Speaker. Mr. Deputy Speaker, it is genuinely an exercise in extreme patience, tolerance, forgiveness, empathy, restraint to listen to the fulminations of the member for Naparima. And I say so, Mr. Deputy Speaker, not to be pejorative to the individual. Obviously, that would offend our standing orders. But really to characterize the level of intelligence behind the arguments that are put forward on behalf of Naparima. Mr. Deputy Speaker, first of all, I'd like to compliment my colleague, the very hard-working Minister in the Ministry of the Attorney General, the Honorable Fitzgerald Hinds, on taking paternity and demonstrating courage to complete the work that has been outstanding for so long. And I say so because Oropuch East had the intellectual gall to stand up, profess that He had written a book on private security industry. He endorsed it, gifted it to the parliament, quoted himself generously, went through to Russell Huggins, coming through to Bastio Pandey, laid the RT at the feet of Siparia in the intellectual and imaginative sense, taking all of that credit, the member did, but leaving out the fact that they didn't have the courage to actually do the work, bring it to the parliament, and pass the law. We hear Naparima, who has fled from the chamber as he always does. Naparima saying, when I was a PNM, and we've heard Naparima talk on many occasions about having resided in the bowels of the PNM. We understand that he came out of the bowels of the PNM and that he is now in the UNC in the position that he sits now. These are the members' own words. That is okay in our country. We have recognized crossing the floor or having the rights for political freedom. But to hear Naparima stand up today and make a mockery of law, and I'll tell you how he did that in a short while, but to stand up and say that this bill is designed for the rich and the wealthy, that this bill is not designed for the poor man. Mr. Deputy Speaker, I didn't come today to speak on this bill, but I'm compelled to answer the ridiculous submissions put forward by Naparima in particular. Naparima has stood in this parliament and said, as it relates to law, Naparima returns to the bill when he actually got it, spent 2 seconds at first, left on a sojourn, and then came back to the bill. Naparima turns to the provisions of the law which deal with offenses, part 11, beginning with section 69, offenses and penalties. And Naparima, whilst hugging the chair of Siparia and jokingly making reference to the bill, comes with the submission of law that offenses and penalties are somehow revenue-generating exercises. Naparima, in making a mockery of law, in making a mockery of this parliament, stands up and says, how are people going to afford these fines? Minimum wage man, how is he going to afford a fine? Not understanding that law must have sanction to be effective. Not caring to understand that it is only with the application of law and the imposition of sanctions that we see changes in our society. After all, who can afford a speeding ticket offered from a gun every 5 minutes? A speed gun designed to catch you while you're going with a heavy offense has caused by its application Trinidad and Tobago to want to drive within the speed limit. So how does Naparima arrive here to say the whole of Part 11 is now a revenue-generating exercise? How else do you regulate an industry such as this? Because, Mr. Deputy Speaker, this is a multi-billion-dollar industry. The movement of prisoners alone by private security transportation mechanisms costs the taxpayers of this country $80 million a year. The implementation...
As the mover of the bill, you will have the opportunity to come back in.
I know that,
No. Okay, yeah.
Mr. Deputy Speaker...
No need to further comment, member, please. Go ahead.
Mr. Deputy Speaker, the imposition upon the taxpayers by way of legitimate business commendably done by private security industry representatives and firms, such as in the movement of transport and transportation of prisoners, to the tune of $80 million a year, is a cost which we must spend. But it is in regulating the industry and in having everybody in the industry managed by way of line of sight, by way of information, that we achieve a number of holistic purposes. And let me tell you what they are. First of all, this law proposes that everybody in the chain of the private industry is registered. The security officer, in any form, whether it be it in respect of property, close protection security services, any form that the law provides, we are providing for a licensing and a public knowledge of who the person is. Peace officers, property protection officers, close protection officers, all of these persons in the law are now to be known. What is the legitimate aim in having the knowledge of who these people are? Their certificates of character, their medical condition, their propriety, their fitness and purpose for the job. That is something, their training, their vetting, their certification. The fact that they hold valid license is something that redounds to the benefit of the whole of Trinidad and Tobago. Because if you are hiring somebody, you ought to have two obligations. Know who they are, firstly. Secondly, you ought to have the right of remedy against them. And this law provides a balancing act for all of Trinidad and Tobago. Because if you are licensing everyone, the individual and the entity in the industry, you now have a right of recourse. But Mr. Deputy Speaker, this bill does something which is critically important. This law provides protection for the thousands of people in the industry. And whilst Naparima considers it a joke, let me refer you, Mr. Deputy Speaker, to clause if we take firstly 59 as just an example, because it's repeated with respect to other agencies. Let's look at clause 59. In the performance of his duties, a peace enforcement officer may, in relation to premises to which he's assigned, do a number of things. Search, examine, exclude and remove persons in other circumstances, detain a person, seize articles, seize weapons, and particularly a close protection order, protection officer in clause 58 is employed, may in the performance of his duty use reasonable force where necessary. When we look to the powers of a security officer under clause 49, again, the power to search, examine, seize, basically move people out. Mr. Deputy Speaker, if we did not define these powers, we are exposing the workers in the industry to civil lawsuit and to criminal action. Because we are now clothing the persons who operate in this industry with the powers in law to do what they ought to do. And that, Mr. Deputy Speaker, is no sneeze. That is a very serious power that we're providing for the protection of the players in the industry. Now, we heard Oropoch East basically make a mockery of the licensing regime and poured scorn upon the fact that one would have to be licensed every 3 years. As the Minister of Finance pointed out, we license an elevator once a year. We license the sale of liquor by special licenses, by occasional licenses, etc., on a periodical basis. As the member for Barataria Sanwan will know, we license private medical hospitals on a biannual basis. Mr. Deputy Speaker, the concept of licensing is something which is well understood in law, because licensing requires and offers an opportunity to refresh information, to have fresh consideration of the propriety of running a business such as this. It provides the employees of the industry with the knowledge that their employers are being regulated, that their terms and conditions are being monitored, that they are effectively in good standing. And one can have no difficulty with a licensing regime, particularly when this bill provides for the rights of appeal to a body set up especially for that purpose, to consider the appellate process not in a court of law where it becomes expensive, but instead, Mr. Deputy Speaker, in a specialist tribunal, in the council conducting its inquiry as it does under this law, under Part 10, in Clause 62, in setting up a tribunal structure for the appellate consideration, we are allowing for a cost-effective management of rights of appeal. And that is to redound to the benefit of all citizens. Mr. Deputy Speaker, there is another extremely important purpose, as I don't intend to be too long in my contribution today, which I would like to just give quick focus upon, and that is the number one issue in our country is crime. Crime is something which affects our economy, our way of life. It affects our confidence, a self-security, a sense of security, the right to your enjoyment of life and your private life and your property are all recognized in our Constitution. If we were to implement a properly regulated industry such as this, we are providing something which we have not had before. We are providing a regulated system of utilization of power in persons who are not police officers. We are effectively expanding the reach of security services in an environment which is safe. On the one hand, the persons that hire these industry players know they are regulated, they are known, they are sanctioned, they have licensings applied to them, there are offenses which they can trip, and on the other hand, the operatives know that they have clothing in law for the powers that they exercise, as I have read out in respect of property officers, close protection officers, etc. Giving them those powers gives them a sense of security to drive to the point that I was just making, which is the expansion of arms and eyes everywhere, as the Honourable Minister, in piloting this motion, set out. Having 10,000 persons in a private security industry join the operationality of the police service in policing our country in known and certain circumstances is no better a goal than one could have for Trinidad and Tobago. And I commend the Honourable Minister in taking the passion to drive this law into its fruition, into moving this Parliament to get to the point. I will end, Mr. Deputy Speaker, by saying the observations made by Oropouche East can be easily addressed. The observations in a joint select committee can be easily addressed. The reasons that we have offered for a joint select committee will include the ability to have stakeholders appear before the joint select committee to iron out the fabric of what this law is to look like, but this law is in large part in good form and in good measure. The question is going to be whether the UNC will support the law. That's what it's about. If we judge the UNC by its track record in spending 5 years and 3 months in doing nothing about the industry, in bringing no law to manage this purpose, in not driving it to successful conclusion, because I will remind that the UNC came in with a statutory objective in a constitutional majority environment. The UNC had the votes at all points in time to pass this law into effect without the participation of a PNM bench. And that is the testimony that Trinidad and Tobago needs to listen to, and we need to pay attention to, because effectively the ball is in the court of the opposition. I denounce the ridiculous submissions made by the member for Naparima. I genuinely believe that the contributions made by Oropouche East can be addressed in quick measure in the Joint Select Committee. This law is in good measure, and this law is certainly something that is designed for the benefit of the smallest of men. And I will say this as I now come to a quick close. When I listen to Naparima regale himself with his stories of having been an executive at NP and saying he couldn't imagine talking about leaving with $1 million, I want to ask the honourable member, whilst he was in the lap of luxury, courting Le Pen, courting persons who are known in very unfortunate ways in the international community, living the life as it was of Riley in the United Nations, how come he had nothing to say about a past member of government, no longer a current member, walking away with $13 million in gratuity from a bank?
Correct.
The member was totally silent when Larry Hawaii walked away with $13 million in gratuity from FCB. The member is now concerned about cabinet reach in appointments. We heard nothing from Naparima, living in the lap of luxury as he did as a representative for Trinidad and Tobago in the United Nations when Reshmi Ramnarayan was appointed. We heard nothing from Naparima then. There was no cry of, oh my gosh, this is the wrong thing to do. We heard nothing from Naparima when NGC awarded the Beetham wastewater project for billions of dollars.
Speaker, one, please.
What?
Overruled.
Point a pair. Taking medicine for somebody else's fever. Mr. Deputy Speaker, in rejecting Naparima's ridiculous submissions, it's important to respond to the scandal put forward by the honourable member. And the best way to answer that is with facts. And it is a fact that Larry Hawaii walked away with $13 million. It is a fact that Speaker Wade Mark refused to allow a ventilation of that issue in this Parliament.
Deputy Speaker,
And
that has no bearing on this bill, Deputy Speaker.
Yes, it does. Security guards lock up thieves.
Chief Whip, your colleague for Naparima, right, started it. Proceed. Overruled.
Naparima, in making his submissions, bumbling as he does in his articulation of ideas. Not that he bumbles, the ideas are bumbling. Naparima says, nice idea, they wake up in VAPs, no thought for thing. Where was the honourable member's voice when the OPVs were cancelled? Where was the honourable member's voice? I see the UNC putting out memes to say that the previous Attorney General saved us $1 billion in OPV claims.
Deputy Speaker, 48-1. Could you draw me to what the OPVs have to do with this bill?
I'm answering.
Cost himself.
Overruled.
Thank you. I'll assist point a pair. I was going to end, but let me finish now a little bit deeper than where I was going to go. The honourable member for Naparima said specifically, nice idea, VAPs, no thought. Then went on to revenue generating, then went on to the application. Obviously, the honourable member opposite was not paying attention to his colleague. I can understand why, myself, but I didn't think that he was that way inclined. But in answering this about bright ideas and waking up with VAPs, the cancellation of the OPVs was the worst idea in Trinidad and Tobago's position. As those vessels now sit, they are labelled in the Brazilian Navy as Trinidad-class vessels. That's the name of the vessel category.
That's true.
As we are now looking to the protection of our borders, not a cry from the lap of luxury in the United Nations while one supped with Le Pen. Secondly,
48-1, Deputy Speaker.
he's already ruled on that. Secondly, in relation to
For the records, overruled.
Secondly, in relation to the failure of a lack of voice and cry from the lap of luxury in the United Nations as Naparima held that position. No cry when we saw the cancellation of the Special Anti-Crime Unit.
Overruled.
Deputy Speaker.
99 times I count the notes.
Member.
Tedious repetition. Sorry.
Overruled.
Mr. Deputy Speaker, the honourable member for Naparima, who is the spokesman for the United National Congress on almost everything, stood in this parliament and made the most ridiculous submissions in relation to this law. And in treating...
Member for Lavington West. Please. Please. All right? I won't have to call on you again.
Oblige, Mr. Speaker.
Thank you, Mr. Speaker. Mr. Speaker, my colleague for Lavington West is so passionate about this law that he takes it to heart. So I understand his passion, which can sometimes erupt. Mr. Deputy Speaker, when we are looking at the submissions in relation to taxation and the raising of revenue and the genesis of this law, I will just simply say, this country is warned. This country is warned to watch the submissions coming from Naparima, corky eye, if I could put it in the most colloquial of terms. Because the honourable member has a profound ability and talent to say one thing and to do another. And there is a very convenient memory that is demonstrated on the part of the honourable member in treating with laws such as this. the submissions that offenses are somehow revenue generation items means that we should have no offense for no penalty and no law in Trinidad and Tobago. Just cut out all of that. Secondly, we should definitely make sure that nobody is licensed in this country. Just cut out all of that. Licensing is unconstitutional. Thirdly, the aspect of providing regulatory framework to make sure there's certainty and precision within the operators of a particular industry, in this case, the multi-billion-dollar industry that is the private security industry. Just take all of that out, because that is unconstitutional. When you strip down the ideas coming from a senior member of the opposition bench, sitting next to the past Prime Minister of Trinidad and Tobago, you have to watch them cocky eye, Mr. Deputy Speaker. And Mr. Deputy Speaker, what I will say, the reason for the move to Joint Select Committee is intended to test the willingness of the opposition to support good law, and one can only pray that they will come with a sincere purpose to engage in this exercise. I thank you, Mr. Deputy Speaker.
Laventil, Minister in the Ministry of Legal Affairs.
Thank you very much, Mr. Deputy Speaker.
General.
Thank you very much. Thank you very much.
Members, listen. Both have your seats. Both have your seats. Chief Whip, I have ruled. Chief Whip, I have ruled. Ministry.
Mr. Deputy Speaker, I got up before the member for Lavendale West.
Before that catches the eye. You didn't catch his eye.
So, Deputy Speaker, thank you very much for recognizing.
Listen, I have ruled and I have ruled. Okay? Minister in the Ministry of the Attorney General.
Thank you very much, Mr. Deputy Speaker. I would like to, of course, begin by congratulating my colleague, similarly the Attorney General, for making a rather incisive response to the incisive nonsense or not making sense submissions of the member for Naparima.
I don't like the word nonsense.
I withdrew.
Right, in terms of how you have categorized it.
I thank you. I changed it to not making sense. Thank you very much. Mr. Deputy Speaker, I would like, in the few remarks that I must render, the Honorable Attorney General, having dealt so comprehensively with the not making sense submissions that we heard, to say, in response to the member for Naparima, who told this Parliament very boldly and very boldly and rather unashamedly, and I rather suspect ignorantly in the purest sense of that word, without knowledge, that there was no consultations before today. Let me place on the record for the citizens of Trinidad and Tobago and for his colleagues who sit with him, who work with him, who hope to return to government with him, hopeless as that obviously is, that is not true. We, Mr. Deputy Speaker, had 3 rounds of consultations in this matter. We consulted with various stakeholders. Let me list them. The Commissioner of Police and his office, obviously and for obvious reasons. The Commissioner of Prison and his office and personnel. The Office of Law Enforcement Policy, otherwise known as OLEP. The Ministry of Labor, because of the labor content in these measures, with an eye on the well-being of those who work in the industry for the operators. We consulted with the University of the West Indies. Mr. Deputy Speaker. Mr. Deputy Speaker, the University of Trinidad and Tobago, from where the member No, it was not the University of Trinidad and Tobago. I was about to talk about the honorary PhD issued in 3 months to the member for Pointe-a-Pierre, but it was not UTT. It was the University of the Southern Caribbean. Because when I first got to know him, he was Dr. Lee. Mr. Deputy Speaker, we consulted with the Ministry of Finance for obvious reasons. The Tobago House of Assembly, this is a national project for the good of all. The Chief Personnel Officer, the Strategic Services Agency, our premier intelligence gathering agency in Trinidad and Tobago, the anti-money laundering, combating the finance, the AMLAC, compliance unit of that, of AMLAC, the Chamber of Commerce, the Energy Chamber, the Bankers Association, the Association of Insurance Companies, because in this bill, insurance and pensions are a critical part for the benefit of those who work in the industry. The RBC, TSTT, TNTEC, NIPDEC, the Chaguaramas Development Authority, all hosting security personnel, COSTAT, G4S, a major security operator in Trinidad and Tobago, and worldwide. Imgin Security Services, a major and long-standing player in the industry in this country. Amalgamated Security Services, long-standing, major share of the market from my observation. The MTS, that National Maintenance, Training and Security Company, which employs thousands and thousands of security officers taking up positions in many public offices around the land. Hella Security, long-standing, well-reputed. Quality Security Bodyguard Services, Innovative Security, SWAT Security, Association of Security Companies, their association, the embodiment in that association, the Estate Police Authority, Trinidad Cement Limited, which hires a significant component of them, the Private Security Network Commission, another critical stakeholder, ASIS, not SIS, ASIS International, Caribbean Institute for Security and Public Safety, a think tank, Professor Ramesh Deosaran, who has been involved in these issues with the police as a former commissioner, chairman of the Police Service Commission, and who would have written extensively from his chair at the university and since. And of course, one person, an individual called Cyril Balbosa, security officer, who made himself available. And we had 3 rounds of consultation. It simply is not correct for the member for Naparima to have come here this evening and to so glibly and shamelessly submit to the desk banging of his colleagues on the other side that we had no consultations. That has to be rejected flatly, Madam Speaker. He told us in his submissions that he came out of the bowels of the PNM. I know the PNM felt a significant relief that having been done.
End of the bubble he came out from.
Yes. And it is now resting somewhere underground. I understand in a cemetery. Madam Speaker, the Attorney General, the member for San Fernando West, as I indicated earlier, dealt comprehensively with his submissions, and I need not waste your time and the time of this Parliament any further in dealing with that. I shall reserve my comments on him for a more appropriate occasion. As for the member for Oropouche East, He told us that there was nothing on vetting in this bill, nothing on fining, to use his word. Madam Deputy Speaker, there's a lot that would go into legislation, but it would find itself in regulations. He spoke about qualifications, and he wanted that to be spelled out, even at this early stage. He spoke about the qualifications of the inspector, an office created under this law. All of these matters, as in many other legislative regimes, would find those details in regulations, not in the parent or the main body of the law. And the member for Oropouche East ought to know that. But he spent at least 20 minutes of his speaking time going on ad nauseum about that, and it is so simple. He recommended that we, on the authority that we are establishing, populate it with persons who are familiar with the sector. I dare say that is there. Spoke about people with experience in the sector, right there before his eyes. But he stands up here today and says it should be there. So you understand why when they were in government, they got things so horribly wrong. Confused. And trying to confuse us, but we will not be deterred. We remain focused, we remain steadfast with one thing in mind, and that is the public interest, the widest and the deepest public interest in all that we do. Unswervingly so, and we remain unmoved. He suggested that there be business persons in front of his eyes. It is there, persons from the business sector without any attachment to avoid conflict of interest with their role or in their role on the authority. So, Madam Speaker, I don't think that he said anything else that need to take up too much of our time at this point. I would like to say, though, that the member for Oropouche East, having, while he was a minister of government, a permanent detachment of innovative security at his home, he should understand a little bit more about the security industry and relations as a citizen with them. He told me here today, I don't know how we arrived at it, I had to stand. The member for Oropouche East, the member for Oropouche East. I think he recommended that I have shrimps.
Twice.
I found it offensive on 2 counts. One, I had never in my life heard of shrimps before. And secondly, I thought deeply about it and I had a sense of what he was trying to talk about. And I had to tell him I'm a hardcore vegetarian. I, man, don't deal with that. To compound his apparent ignorance, he was making, don't tell me a word about pronunciation, it's that I'm dealing with now, his pronunciation. He saw a restaurant somewhere in the, One Woodbrook Place. It is spelled C-H-A-U-D. It's a French word. He told, what do you call it? Chowd. He called it chowd or chad or chowd or something. Look, remember like his tongue is twisted around his eye tooth so he can't see what he's saying. No, the word is show. The word is show.
To get you incensed.
Right? To get me incensed? I am unmoved, I told you that. I am like the rock of David, you can't move I at all. Madam Speaker. So I don't know why he brought me into his affairs with his shrimp and all that. I have gone to show, and I had a wonderful pasta and mushrooms. And I'm planning at some stage again to enjoy. Yeah, we're talking about that. We're talking about that. And I am not, unlike, in conclusion, since he raised that, I am not going to do like the member for Oropouche East, take up almost permanent residence in the Hyatt and in a room in St. Lucia. and have no champagne with nobody. Because I don't drink alcohol either. Jealous? I don't want no part of that. So, Madam Speaker, I have heard my colleagues on the other side, and we, as an open-minded, transparent, well-meaning government, we do two things. We came to this House with these measures and recognizing some of the issues might need further ventilation and analysis. We offered initially that this be taken to a Joint Select Committee, which we have announced.
Venting, not ventilation.
We will also, Madam Speaker, assure the national community that we keep an open mind and an open heart in metaphor to all ideas. As a matter of fact, we envisage that we'll have other stakeholders or those stakeholders visit with us again during the course of the Joint Select Committee proceedings so that we could, when we come back here to debate the report of the Joint Select Committee, it should be a product that all are on board with, and the Express editorial from which I quoted today, which suggested that it should get the support of both sides of the House, and questioned as to why it took so long, will be questions that we would have answered by our conduct in the interest of the people of Trinidad and Tobago, both sides of this House. So we did that. We did that. The member for Oropuchis protested at the idea of issuing licenses that would expire, that have a life of 3 years. We considered that 3 years was quite reasonable, and he was condemnatory on that matter. He finds that 3 years is too short in the life of a business and so on. I just want to remind the member for Oropuch, before I come to a conclusion, that private hospitals are required to be assessed on an annual basis. Doesn't matter. Doesn't matter. Doctors have to have their licenses, their authority to practice renewed on an annual basis. Lawyers as well. Pharmacists. Pilots. In the civil aviation industry, very stringent rules for aircraft, for operators, for workers, especially for pilots. The member for Oropuchis is pretending he doesn't know that. And he's suggesting that it is too onerous on an operator in this business. I had to ask the member for Naparima when he was making his uncompelling arguments, that I had to remind him, Madam Speaker, that, you know, this is normal. We live in a world of terrorism. This is not just about security to protect us from crime and violence, you know. We contemplate as well the issue of terrorism. There are many places in this country and in this world where private security operates in that protection. And we are very vulnerable to terrorists. And on the business of keeping permanent records, imagine the member for Naparima has a problem with that. I had to have him know that when you join the public service or one of the agencies of the state, at the age of 18, as I did, they keep a file on you all the way through and even after you retire at the age of 60 or 65. And that is not just so, that is for very good reason. So that if we discover a security operator firm was misconducting itself, breaking the law, according to them, we should wait until 5 years or 7 years before we are able to review them and to treat with them. Madam Speaker, we don't consider that to be sensible, but again, these are matters that we can deal with going forward. So I promised myself, and I promised this House that I will not be long. I will not keep you very long. So we will continue, Madam Speaker, to take the approach that we have. We brought the measures here. We'll take it to a joint select committee. We will deliberate upon it. Independent senators, members of the Senate, members of this House on both sides will have an opportunity to bring to bear their intellect, their human experiences, all of the skills that we have as varied kinds of professionals in this place. And having so done, the product, the outcome, should be that which Trinidad and Tobago is proud of. So, Madam Speaker, in those circumstances, and without more, I beg to move.
Honourable members, the question is that a bill entitled An Act to Establish the Private Security Service Authority and to regulate the private security industry and for other related matters be now read a second time. All in favour say aye. Aye. Any against? The ayes have it.
A bill entitled An Act to Establish the Private Security Service Authority and to regulate the private security industry and for other related matters.
The Minister in the Ministry of the Attorney General and Legal Affairs.
Thank you very much again, Madam Speaker. Madam Speaker, in accordance with Standing Order 68-1, I beg to move that the Private Security Industry Bill 2019 be referred to a joint select committee hereby established for that purpose, and that this committee be empowered to consider and report on the general merits and principles of the bill and report to this Honourable House by September the 27th, 2019.
Honourable members, the question is that the Private Security Industry Bill 2019 be referred to a joint select committee hereby established for this purpose, and that this committee be empowered to consider and report on the general merits and principles of the bill and report by September 27, 2019. All in favour say aye. Aye. Any against? The ayes have it. Minister in the Ministry of Attorney General and Legal Affairs.
Thank you yet again, Madam Speaker. Madam Speaker, subject to the concurrence of the Senate on this matter, I beg to move that this House appoint the following members to serve on the Joint Select Committee on the Private Security Industry Bill 2019. Mr. Fitzgerald Hinds, yours truly, Mr. Stuart Young, Mrs. Glenda Jennings-Smith, Brigadier General Retired Ansel Antoine, Mr. David Lee, and Dr. Rudal Munilal. Thank you, Madam Speaker.
Honourable Minister, is yours truly part of your title?
It is not.
Okay, so I'll now put the question. Honourable members, the question is that this House appoint the following members to serve on the Joint Select Committee of the Private Security Industry Bill 2019. Mr. Fitzgerald Hinds, Mr. Stuart Young, Mrs. Glenda Jennings-Smith, Brigadier General Retired Ansel Antoine, Mr. David Lee, Dr. Rudal Munilal. All in favour say aye. Aye. Any against? The ayes have it. The Minister of Agriculture, Land and Fisheries.
Madam Speaker, I beg to move that a bill entitled An Act to Amend the National Emblems of Trinidad and Tobago Regulation Act, Chapter 1904, be now read a second time. Madam Speaker, thank you very much for affording me the opportunity to visit this chamber. I do not intend to abuse this invitation. In summary, Madam Speaker, this is a short bill which seeks to make a single change to a schedule to a short act which is only 9 sections. That short act, Madam Speaker, is the National Emblems of Trinidad and Tobago Regulation Act. It was enacted in 1967, and the intention was to deal, Madam Speaker, with the introduction in time for the country's independence in 1962 of three named national emblems. Those emblems are the coat of arms, which, Madam Speaker, is above your head, the national flag, which is on your right side and on your left side, and the national flower, which is not at present in this chamber. But once this House agrees with me this evening, we would ensure that the double Shakonia is on display even in this House. And this short act, Madam Speaker, sets out to put in place provisions for the preservation of the copyright in these national emblems, the opportunity for the minister responsible to grant licenses in relation to the use of these national emblems, the composition and the opportunity to appoint a National Emblems Committee to deal with matters relating to the emblems, and most importantly, in the one schedule to the Act, to set out in three parts the description of these three national emblems. And when you look at the schedule, Madam President, Madam Speaker, you see two things which are very evident. The first is that part one of the schedule deals with the coat of arms. And I do not invite you to look above your head, but you can take my word for it. This country's coat of arms is distinctive and it is unique. It is not something that can be used elsewhere. It belongs to us, and we have provisions in place to protect it. If you look to your left and your right, part 2 of the schedule addresses that, the national flag. And there is no doubt that our national flag is distinctive in its design, not only because of its colors, but because of its unique design. And distinctiveness and uniqueness are important to any national flag. Part 3 of the schedule, Madam Speaker, deals with our national flower. And it describes the national flower in its biological name and also in names that are familiar to our citizens, the wild poinsettia, the pride of Trinidad and Tobago. But, Madam Speaker, therein lies the problem. Even before the national flower was identified as a single Shakonia, a debate had already started in the country. And that debate deals with the uniqueness of the single Shakonia. And it is now well established, 57 years after, it is now well established that the single Shakonia is not unique to Trinidad and Tobago. It is found in those places which enjoy similar temperature to our country and similar conditions to our country. And even before the national flower was officially recognized as the single Shakonia, a debate had started about the truly unique flower to our country, which is the double Shakonia. And until now, despite all the debate and the discussion, we've not had the opportunity to correct that. In fact, in that Act of 1967, we've only interfered with it once, in 1980, to include what is now Section 9, which is a validation provision to deal with matters dealt with prior to 1980. And it is not something that you're going to touch very lightly, Madam Speaker. It's not something that you're going to interfere with unless you have conviction and unless you have the support of those who know best. And in this debate stands out a series of persons, including Professor Julian Kenny, for example.
Hey, good man.
Entities like the Field Naturalist Club, the National Herbarium, the University of the West Indies, the Horticulture Society of Trinidad and Tobago. And over the years, there have been numerous publications, recent publications, in fact, by the University of the West Indies, setting out over and over the case for the recognition of the double Chaconia as the national emblem of this country. National flower amongst the 3 national emblems. So this bill, Madam Speaker, as I have said, is a short bill, 3 clauses. And the objective of the bill is to amend Part 3 of the schedule to the short act to which I have referred, and to make a single change. And that single change is to recognize now, instead of the single Chaconia, the double Chaconia as the national flower of Trinidad and Tobago. And when you go to Clause 3, Madam Speaker, you would see the reference to David Oyong. And David Oyong was one of the horticulturists who accompanied Grace Malone to that trip to northeast Trinidad in the 1950s when the double Chaconia was first identified. And the name attached to what we propose as the amendment to Part 3 of the schedule recognizes David Oyong's role as the person who developed the cultivar which gives rise to the opportunity to propagate the double Chaconia. Grace Malone, who was the other horticulturist on the trip, did not go recognize. Is ironic or coincidental that in 1987 she was awarded the Chaconial Medal for her contribution to horticulture in Trinidad and Tobago. Madam Speaker, it's Friday and I do not wish to abuse my privilege. I've come to this House simply to put forward this bill to ask for this change, as small as it is, extremely significant to Part 3 of the 3rd schedule. And Madam Speaker, I do not wish to detain you anymore. I beg to move.
Honourable members, I shall now propose the question for debate. The question is that a bill entitled An Act to Amend the National Emblems of Trinidad and Tobago Regulation Act, Chapter 1904, be now read a second time. Member for Oropouche West.
Thank you, Madam Speaker, for this opportunity to join in this debate and also to respond to the Honourable Minister on the bill, the National Emblems of Trinidad and Tobago Regulations, Amendment Bill 2018. Madam Speaker, as the Honourable Minister said, this bill is rather short. 3 clauses. Clause 1, which represents the short title of the bill. Clause 2, which is the interpretation, and interpretation to the words the Act, which means the national emblems of Trinidad and Tobago. And Part 3, which is Part 3 of the schedule amended to replace the word Chaconia with the words double Chaconia. Madam Speaker, this session here is not really a botany exercise, but the single Chaconia is really the wild type plant that is found in equatorial regions of the world, like in Peru and Ecuador and Brazil and so. And the double Chaconia is really the mutant, which is really indigenous to Trinidad and Tobago.
You should be the Minister of Agriculture and guess that.
Madam Speaker, I have listened to the Honourable Minister, and I have also looked at his contribution with the Hansard records of the Senate. And when I went through the Hansard record, Madam Speaker, I saw that the Honourable Minister said this, to change the single Chaconia to the double, was a cabinet decision 1 year ago. And 1 year ago also, the cabinet took a decision that the Chaconia should be planted on the grounds of every school in Trinidad and Tobago. And he said that was not by an accident. What I need to ask the Honourable Minister here, Madam Speaker, is what is the status of this grand project to plant the Chaconia in every school in Trinidad and Tobago. I would let the Honourable Minister know that I have 14 schools in Oropuch West, 11 primary and 3 secondary schools.
I don't know if I remember familiar.
And as a member of parliament, you would go to these schools for different reasons. And since last year, I have been visiting these 14 schools, and to date, I have not seen any Chaconia planted. I'm not sure if we could call it a plight of the missing Chaconia, Madam Speaker, but none has been planted. In fact, the students of Ramai Trace Hindu School, Madam Speaker, had asked me when it is that the double Chaconia is going to be planted in their school. But their school, Madam Speaker, the children are going to a temple for the last 3 years to get school sessions and to get school to learn.
Member for Oropuch West, I have allowed you some latitude. This is not a debate about schools. So I am anticipating where you're going. This is not a debate about schools. So quickly tie what you're talking about with the lack of the double Chaconia in your schools back to this debate. We're not talking about schools and temples. Please.
I heard you, Madam Speaker.
Please move on.
Yes,
Thank
I
you.
would move on, but you see, Madam Speaker, we cannot be anticipatory in this parliament because we need to see the nexus.
Member, if you wish the opportunity to go on, press on, you can. Just don't go back to where you've just come from.
Thank you. Thank you, Madam Speaker. So, Madam Speaker, the other point that the Honourable Minister said from his contribution from the Senate, or the other place, sorry, is that this plant is rather difficult to propagate. And I am wondering if the Honourable Minister realizes that with agriculture comes science. And this plant cannot be difficult to propagate, Madam Speaker, because if you look at the physiology of this plant, you would see the double Chaconia, you would see that it gives an inflorescence at the terminal bud. It also gives an inflorescence at the axial node. And if it gives at the axial node, you could do budding of that plant.
Yes,
and then you could also do tissue culture, Madam Speaker,
this
because
Augustine nursery
the
wonder.
plant has the meristematic regions where you can also take and propagate the plant. So I am saying to the Honourable Minister that when you're dealing with agriculture, technology is important. And once technology is important, Madam Speaker, you could create an environment where the plant exists in its natural habitat by controlling humidity, by controlling temperature, by controlling water intake, and create that environment by modifying your conditions. So the plant is not difficult to grow, and in so doing, you can have plantlets to grow into the different schools on the compound and enable the children to have that national pride and say that is the Chaconia, the emblem of Trinidad and Tobago. The other thing, Madam Speaker, is that we have a polymer birth certificate in Trinidad and Tobago. And on that birth certificate, Madam Speaker, you would see a single Chaconia. That's the emblem. A single Chaconia, which was our national flower. But this polymer birth certificate, Madam Speaker, was enacted or processed in 2016 under this PNM government. And during that time, they would have known their legislative agenda. And they would have known that we are going to change the single Chaconia to the double Chaconia. So while roll out a birth certificate, if you know you're going to change your polymer birth certificate into the double Chaconia. So there's a cost to the taxpayer, Madam Speaker. And if, Madam Speaker, take for example, my constituents in or Pooch West. If I were to tell Ramlal, check his birth certificate, on the top left, you would see 1 row of sepals. But you know what? We are going to get 2 rows of sepals. How is that going to impact his life when he needs water? How? What benefit will accrue to Ramlal, Madam Speaker?
Member, this is not a debate about water. I'm not allowing you to go there. Please get back to the bill. Please.
On the other note, Madam Speaker, if we are going to protect this plant, we have to have intellectual property rights. Intellectual property rights. What we have, Madam Speaker, is that we have enabling legislation from 1978, the International Convention for the Protection of New Varieties of Plant, Madam Speaker. We also have what is called international agreements, major international conventions, Madam Speaker. We are the signatory to the Convention of Nature Protection and Wildlife. And we are also signatory to the protocol concerning specially protected areas, and also the Convention on the Conservation of Biological Diversity. My point is, Madam Speaker, if we are to have this plant protected, we have to engage and use the enabling legislation so this plant can be protected and you do not have what is called poachers. Just as we have the scarlet ibis being poached, Madam Speaker, so too, this plant will become an exotic plant, and we will have other persons trying to poach the plant. What I mean by being poached, Madam Speaker, is that you now will use this plant as for beneficial purposes, because with technology, budding becomes easier, and now you could propagate your own plant and use it to bring in revenue for yourself. So what is it, the policy of the Ministry of Agriculture? The Ministry of Agriculture, their policy in creating that own niche and capturing what is called the exotic flower market. Also, Madam Speaker, has the conservator of forests been involved in certain areas where the flowers grow in its natural state? Because, Madam Speaker, what we have really happening is that in the forested area, you will have persons doing illegal quarrying, you have forest fires, and you have deforestation.
Madam Speaker, with the deepest of respect, Standing Order 48.1. This is not about propagation, forest. Please, 48.1.
The objection is upheld.
So, Madam Speaker, the Honorable Minister spoke about one of the national emblems, which is the Trinidad and Tobago national flag. He invited you to watch on both sides. But I want to invite everyone here and to remind you that when you are traveling down to south and you pass Prisal and you reach Couva,
There's a flag.
there is a beautiful white building with a flag. The national flag, red, white, and black. And that building is a children's hospital. And we will have pride. We will take pride with that will be open.
Member.
Just like
Member for Oropuch West, I'm on my legs. I'm allowing you one more opportunity to get back to this bill. If not, then I will invite you to take your seat.
Madam Speaker, as I was winding up, I am saying that beautiful emblem will give us, because this Chaconia represents the pride of Trinidad and Tobago. And I am saying that building, which is the Children's Hospital, were to be opened, we will be proud. Thank you, Madam Speaker.
Member for San Fernando East. Minister of Agriculture? Minister of Agriculture. Minister of Agriculture, Land and Fisheries.
Thank you very much, Madam Speaker. Madam Speaker,
You are dumbfounded.
I want to thank the member for Oropuch West for taking me through the 41 constituencies. And I respond in this way, Madam President. My friend from Oropuch West has a degree in agriculture and is an attorney at law. And she's used parts of both, but not necessarily the important parts of both. Madam Speaker, let me deal with the absence of an understanding and appreciation of the law. I have been to 108 schools as Minister of Agriculture. In fact, I went to my friend's constituency, Woodland Hindu. She could not make it that day. And I had a very long discussion. I had a very long discussion with the children at that school, saying to them, we are committed to have the national flower planted in every school in Trinidad once it becomes the national flower. I could only do that if I complete my work here this evening and we complete the work that has to be done elsewhere. So, from a legal point of view, we intend to do that once it is the national flower. But from an agriculture point of view, my friend should also know that even David Oyong in the 1950s had great difficulty in propagating, as I said in my opening. In fact, Madam Speaker, I refer to, of the several meetings we had, I refer to one held on the 7th of February 2018, a meeting attended by the Trinidad Garden Club, Eastern Horticultural Club, National Herbarium, Field Naturalist Club, Citizens for Conservation, La Vega Estate, Trinidad and Tobago Orchid Society. And at that meeting, Madam Speaker, Yasmin Como from the National Herbarium made a few points that my friend may benefit from. She made the point first that the double Chaconia has a recessive gene and a limited genetic pool. It is a high-risk mutant plant and a unique botanical specimen. It is difficult to propagate. And in the year that has passed, as my friend referred to it, the ministry, together with the Horticulture Society, has been propagating the national flower in anticipation of the double Chaconia being proclaimed so that we could plant in the schools. But it is a difficult plant to propagate. My friend has talked about the natural habitat and having the flower in the natural form. And Ms. Como made this point. She said, the double Chaconia is considered extinct in the wild and only exists in the cultivated form. In other words, it is through propagation that we would have the Chaconia. It is not something that you could walk into the forest and pick out plants and so on. There is no natural form for its existence. It's cultivated, and that is what we've been doing. And the third point and final point I will address is this issue of the polymer birth certificate, Madam Speaker. And I recall, in fact, in a debate in the other place, I made reference to my father's birth certificate. It was a beige color paper, handwritten. In fact, in that debate, I said the word illegitimate was written on my father's birth certificate. My own birth certificate was white, written in black ink. There are other persons who came along after me and got a blue electronic birth certificate. And those who came even after got a polymer birth certificate. Nothing has rendered any forms of that birth certificate unavailable for use for official business. There is absolutely no danger. The coins that bear the single Shakonia will continue to be valid tender. And it is not strange. So I don't think the people from Oropouche West need worry about this small change being made affecting the legitimacy of any of their official documents or anything in their possession currently marked with a single Shakonia. In time to come, it may be marked with a double Shakonia. With those words, Madam Speaker, I beg to move.
Honorable members, the question is that a bill entitled An Act to Amend the National Emblems of Trinidad and Tobago Regulation Act, Chapter 1904, be now read a second time. All in favor say aye. Aye. Any against? The ayes have it.
A bill entitled An Act to Amend the National Emblems of Trinidad and Tobago Regulation Act, Chapter 1904.
Minister of Agriculture, Land and Fisheries.
Madam Speaker, in accordance with Standing Order 68-1, I beg to move that the National Emblems of Trinidad and Tobago Regulation Amendment Bill 2018 be committed to the Committee of the Whole.
Honorable members, the question is that the National Emblems of Trinidad and Tobago Regulation Amendment Bill 2018 be committed to the Committee of the Whole. All in favor say aye. Aye. Any against? The ayes have it. The House will now go into the Committee of the Whole to consider the bill clause by clause. Where? Are we proceeding? All? Minister, all en bloc?
Clauses 1 to 3.
The question is that clauses 1 to 3 stand part of the bill. The question is that clauses 1 to 3 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clauses 1 to 3 now stand part of the bill. Honorable members, the question is that the bill be now reported to the House. Those in favor say aye. Aye. Those against say no. I think the ayes have it. This committee meeting is now adjourned. The House will resume. Minister of Agriculture, Land and Fisheries.
Madam Speaker, I wish to report that the National Emblems of Trinidad and Tobago Regulation Amendment Bill 2018 was considered in the Committee of the Whole and approved without amendments. I now beg to move that the House agree with the committee's report.
Honorable members, the question is that this House agree with the committee's report on the National Emblems of Trinidad and Tobago Regulation Amendment Bill 2018. All in favor say aye. Aye. Any against? The ayes have it. Minister of Agriculture, Land and Fisheries.
Madam Speaker, I beg to move that a bill entitled An Act to Amend the National Emblems of Trinidad and Tobago Regulation Act, Chapter 1904 be forthwith read a third time and pass.
Honorable members, the question is that a bill entitled An Act to Amend the National Emblems of Trinidad and Tobago Regulation Act, Chapter 1904 be forthwith read a third time and passed. All in favor say aye. Aye. Any against? I think the ayes have it.
A bill entitled An Act to Amend the National Emblems of Trinidad and Tobago Regulation Act, Chapter 1904.
Honorable members, debate on the second reading of the following bill, which was in progress when the House adjourned on Friday, May 24, 2019, will be resumed. A bill entitled An Act to Amend the Petroleum Act, Chapter 1601, the Petroleum Production Levy and Subsidy Act, Chapter 6202, and the Income Tax Act, Chapter 7501. The Minister of Finance, you have 12 minutes of original speaking time left.
Thank you, Madam Speaker. I won't be long. I assure you I won't be long. Madam Speaker, on the last occasion, we did not complete the winding up of this bill because we had to look carefully at whether we wanted to continue with the amendment to the Income Tax Act. I can say now that we do not intend to go ahead with that at this time. We will have another time to do that. And in fact, we have legislation before a parliamentary committee dealing with a related matter. So it's appropriate that we leave that alone for the time being. A number of allegations were made on the last occasion. A number of questions were asked, but particularly by the member for Caroni Central. And I would just like to put on the record now, Madam Speaker, what the facts are. In particular, because this bill touches on the operations of the restructured Petrotrin, which was restructured into 4 companies, namely Old Petrotrin, Guaracara Refining, Heritage Petroleum, and Paria Fuel Trading. Questions were asked whether the long-term security of these companies was assured in the context of a bond issue that comes up for renewal in August of 2019. And that is a $850 million US bond that was issued several years ago for upgrade of the Pointe-a-Pierre refinery, among other things, and it is due for repayment. It's a repayment by a bullet payment in August of 2019. Madam Speaker, on the 15th of April, not certain exactly when we were doing this bill on the last occasion. I'm sure it was after the 15th of April, though. On the 15th of April, the online news wire called PR Newswire, which is a publication that follows the capital markets and the bond markets in the United States, published a document as follows. Trinidad Petroleum Holdings announces the commencement of offers to exchange any and all of its 9.75% notes due 2019 and 6% notes due 2022 for new US dollar denominated 9.75 senior secured notes due 2026, and if applicable, with respect to the 9.75% notes due 2019. Last week, Madam Speaker, Trinidad Petroleum announced that it had secured all of the required financing, conditional commitments, because there are several things that still have to be done, Madam Speaker, in a complex transaction like this. There's a lot of paperwork to be done. But when you approach a financial institution or a consortium, as it is in this particular case, they will give you a commitment with certain conditions precedent to disbursement. And last week, Trinidad Petroleum announced that it had met the requirements to receive a conditional commitment from the consortium of banks, essentially led by Credit Suisse, and including BladX and FCB, the local counterpart, and Morgan Stanley, for loan financing in the amount of $720 million US. The other $130 million US was to be, or is to be, refinanced by a bond swap, where existing bondholders would swap the bonds that they have that are maturing in August of this year for new 7-year bonds at the same interest rate. The original plan, Madam Speaker, the original plan was that approximately 425 million of the bonds would be swapped out, and 425 million US dollars would be financed by a loan. There was a minimum condition of acceptance by existing bondholders that at least $150 million worth of these bonds, these two bonds that I just called out, would be accepted for swap. Trinidad Petroleum also met that criteria, so that the plan up to last week was that 130 million US would be swapped out and 720 million US would be refinanced by way of a loan. The terms on the loan are actually better than the terms on the bond swap, in that the bond swap is at the original interest rate of 9.75%, and the loan, would you relax, Madam Speaker? Thank you. I don't know why they're so jumpy. I'm talking. I'm still speaking. I haven't finished. Thank you, Madam Speaker. The bonds will be swapped out at an interest rate of 9.75% for new 7-year bonds at 9.75%. And the loan was a combination of a 3-year facility and a 7-year facility. The 3-year facility, the reduction in the interest rate was 150 basis points, so 1.5%. So if you deduct 1.5% from 9.75%, you would get 8.25% is the loan for the 3-year loan facility. For the 7-year, it was a reduction of 50 basis points, which would take it down to 9.25%, so that Trinidad Petroleum, by the end of last week, had secured commitments for loan financing up to 720 million US and a bond swap of 150. Subsequent to that, the company continued to speak to bondholders to see if they could increase the amount of bonds to be swapped. And there is an article in the newspapers today. You know, of course, it's in the newspapers, so that one has to test the accuracy. But in the Newsday today, there is a group of bondholders. It is indicated in the Newsday today that there's a group of bondholders who have come back to the table, and they have decided to participate in the bond swap in an additional sum of 273 million US dollars. So if you add the 273 to the 130, and if all of that is taken into account, you will get about $400 million in swap and $450 million more or less in financing. But the point is, Madam Speaker, whichever way it turns out, the Trinidad Petroleum has done what they were supposed to do, and they have secured commitments for the refinancing of that US $850 million bond issue. Just a minute. For which, Madam Speaker, it was not easy, for which the board of Petrotrin, the board of Trinidad Petroleum, the board of Heritage Petroleum,
and the board of PARIA and all of the persons involved in this exercise must be congratulated, Madam Speaker. It wasn't easy. And I'll explain why it wasn't easy. You had the previous entity, Petroleum, which had a very poor history, a very poor payment history, a very poor credit rating, a history of losses. That was then restructured into 4 companies. And the company that went to secure this refinancing was brand new. It was only created in and around November of 2018, and therefore it had no history of profit and loss, no history of earnings, no history of payment of taxation. So that for this reason, Madam Speaker, because you had an old company that was not in very good shape, a brand new company that has no record, no track record per se, I think it was a fantastic achievement on the part of the board of these companies. The other thing that must be said, Madam Speaker, is that PARIA Fuel Trading, a startup company that began towards the end of November, which imports fuel, gasoline, diesel, aviation fuel, etc., sells about 50% of what it imports in Trinidad and Tobago and distributes the other 50% more or less to the region, was virtually profitable from inception. Profit is not high, it's a margin business, but PARIA Fuel Trading, I am told, was profitable almost from the beginning. Heritage Petroleum, a startup company as well, which had to take over all of Petrotrin's oil fields, pipelines, offshore platforms, production facilities. They had to start again from scratch from the 1st of December with a much smaller workforce, completely different system. Madam Speaker, they had a small loss in the first 2 months of operation, but I'm happy to announce that as of today, in June, Heritage Petroleum is also profitable. So we have come from a situation where we had a heavily encumbered, Madam Speaker, I would seek your protection. This grumbling, I just can't take it at 7 o'clock in the night. I'm seeking your protection.
Honourable members, maybe having regard to what the Honourable Minister is reporting, maybe somebody might wish to move the proper standing order and make an interjection, and maybe he will be gentlemanly enough to allow. Okay? But how could, I was just warned that we can't be anticipatory, so maybe we can try. But I would like to hear the member. Minister of Finance.
Thank you, Madam Speaker. So as I said, Madam Speaker, the company that we are resolving some amendments to the Petroleum Act, the Petroleum Production Levy and Subsidy Act.
Finance, your original 12 minutes are now spent. You now have 15 additional minutes of extended time if you wish.
Thank you very much.
Proceed.
Thank you very much. Madam Speaker, PARIA Fuel Trading, we need to regularize some of the definitions in the Petroleum Act and the Petroleum Production Levy and Subsidy Act. This does not affect, Madam Speaker, the retail price of motor fuels, the price of gasoline at the pump, the price of diesel at the pump. It does not affect that. But because previously there was no real history of importation of fuels and distribution, it was a production facility, the law did not really cater for a trading company. So what we're about today is just to tighten up some of the definitions to include the definition of a trading company, Madam Speaker. But I simply wish to say that we have gone from a situation where we had an integrated oil company, which was exploration and production together with refining and marketing. So we had a company that did everything. It did exploration, it did oil production, it did oil refining, and it did marketing of petroleum products. We've gone from that situation into a situation where we have a standalone production company, Heritage Petroleum, and a standalone fuel distribution company with the marketing side of the R&M that was in the old Petrotrin. And we need to tighten up some of the language in the current legislation in terms of dealing with how we properly account for the subsidy and so on. And if I go to the schedule, Madam Speaker, may I say, the Attorney General has advised me that there was some typographical some typographical errors.
And some printing errors.
Yes, some printing errors, I'm sorry, Madam Speaker. In the production of the bill before the House, there were some printing errors. So we need to correct that. And there is a list of amendments that has been circulated to members. But it doesn't change the import, the purpose, the purpose, intent, and purport of the bill, Madam Speaker, because the principle remains the same, that we are now setting a price based on world market prices for gasoline, kerosene, auto diesel, and so on, Madam Speaker. And it's based on a reference. So there will be some amendments which we will take through at the committee stage. But, okay, all right, no problem.
Thank you very much, Mr. Greenway. Just two issues. The loan that we're going to search for, whether it's 400 million or X amount, who is going to stand the guarantee for that loan? Is it that Trinidad Petroleum or Heritage or the state? That's number one. And did you seek to get a lower interest rate other than 9.2% or so? Did you do a market search to see if you could have gotten a lower interest rate rather than the 9%? If you want to answer, we'll appreciate that.
Thank you very much. Madam Speaker, the original bond was not guaranteed by the state. And it was not guaranteed either by the assets of the then Petrotrin. At the time, the price of oil was so high. It was, in those days, it was upwards of $140 a barrel. And therefore, simply on cash flow, the lenders at the time were willing to lend the money without any guarantee from the state. This is one of the challenges that the new Petrotrin, or the restructured company, faced. Because whereas 10 years ago, or 12 years ago, the lenders were willing to finance this bond without a government guarantee, with prices of oil half or less of what they were 10 or 12 years ago, it was a serious challenge. It was very, very difficult for the company to secure the refinancing without a government guarantee. And that's why I have to congratulate them, because this conditional commitment they have is without a government guarantee. Believe it or not, there is no government guarantee for the refinancing, as there was no guarantee for the original bond issue. Well, it will be the companies will secure the Trinidad Petroleum, Paria Fuel Trading, their assets, secure the loan, but there is no government guarantee, so it does not add to the public debt. It's not a contingent. It is not a contingent liability, and it is not part of the national debt. And that's why we must give credit where credit is due. To go outside there in this go of a season with oil at $50 and $60 and so on, and with a company has had a history of losses for so long, to get financing of $850 million US, that's not a small sum of money. That is a significant sum. That's over 5 billion TT dollars. And to get that without a government guarantee, they must be congratulated. And the interest rates, firstly, the government did not negotiate this. The company did. But we felt that in the spirit of the new restructured organization, we should allow them to go ahead and do the financing, get some credibility in the market and so on. And I think they did very well to get these reductions in the interest rate on the loan side, because it did not appear possible at the beginning. And I think they did a fairly good job in terms of the reductions that they got, the 150 basis points and the 50 basis points. And even the swap, I think they did an excellent job. And I want to make a point. When I was in Washington in April, and we met with some experts that deal with credit ratings of countries, ex-Moody's, ex-Standard & Poor's employees, who are consultants now, they told us that when they worked at the rating agencies in the past, and they were rating Trinidad and Tobago, and this goes back even to the time of the previous government, and they would rate Trinidad and Tobago as a sovereign nation. The credit rating was well into the investment grade. But when you add in Petrotrin dragged our rating down 3 and 4 points in the rating. In fact, on the last occasion, Petrotrin dragged us out of the investment grade into what is called a speculative grade. So that Petrotrin has been quite a burden on this country, and people don't realize that now that the Petrotrin problem is solved or is being solved, it is going to eventually, not immediately, because again, the rating agencies will have to look at Heritage and Paria for a little while to see how they're going to perform, make sure they make their loan payments and so on. But it is going to improve the country's credit rating. The national credit rating is going to be improved because of the things that have been done with Petrotrin, the restructuring. And so, Madam Speaker, as I said, this bill is simply tightening up some definitions on how we calculate the subsidy and how we define pricing and introducing the concept of a trading company. And as I said, there are some amendments which we will take our time with at the committee stage and explain them as the best as we can. And therefore, I beg to move, Madam Speaker.
Honorable members, the question is that a bill entitled An Act to Amend the Petroleum Act, Chapter 6201, the Petroleum Production Levy and Subsidy Act, Chapter 6202, and the Income Tax Act, Chapter 7501, be now read a second time. All in favor say aye. Aye. Any against? The ayes have it.
A bill entitled An Act to Amend the Petroleum Act, Chapter 6201, the Petroleum Production Levy and Subsidy Act, Chapter 6202, and the Income Tax Act, Chapter 7501.
Leader of the House.
Thank you very kindly, Madam Speaker. Madam Speaker, in accordance with Standing Order 15.5, I beg to move that the House continue to sit until the conclusion of the matters before it.
Honorable members, the question is that this House continue to sit until the conclusion of the business before it. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Minister of Finance.
Thank you, Madam Speaker. In accordance with Standing Order 681, I beg to move that the miscellaneous provisions, Petroleum Production Levy and Subsidy and Income Tax Bill 2019 be committed to a committee of the whole.
Honorable members, the question is that the miscellaneous provisions, Petroleum Production Levy and Subsidy, and Income Tax Bill 2019 be committed to the committee of the whole. All in favor say aye. Aye. Any against? The ayes have it. This House will now go into the committee of the whole to consider the bill clause by clause. Minister, are you ready? Whip, are you ready? Okay, so, members, just for your guidance, having regard to the amendments which have been circulated, Clause 1, consideration of Clause 1, shall be deferred until we consider the proposed amendment to Clause 4. So we'll do the long title, and then we go to Clause 2. And, yeah, the long title is done last in any event.
Yep.
So we're going straight to Clause 2. Okay? Clause 2. The question is that Clause 2 stand part of the bill.
Minister, Clause 2C, as you have it there, and B. The B.
Just 1 minute, please, Member for Caroni.
Sure.
I think we better allow the minister to present, and
Sure.
then.
Right, okay.
Okay, thank you. Minister of Finance.
Thank you, Madam Speaker. Madam Speaker, there was a printing error with the schedule. So,
Clause 2 first.
yeah, I know. So I'm just saying that as a opening point. When you go to the original bill, on page 2, Clause 2, subsection 1, subsection C, what you call that? An
2,
addition?
Roman 2.
No, you call it additional subsection 2. Subparagraph 2. I'm getting some training here. The current bill as it stands has that we are inserting after the definition of marketing license the following definition, which is the definition I spoke about, trading business. And we are taking that out and we are replacing that with in the appropriate alphabetical order. It's simply a formatting change. So I don't know if the member had a question.
Not on that aspect. I just wanted to ask the issue of changing it from sale to resale. Could you give a little...
All right, so let's just go by one. So we, in Clause 2,
A.
Where we're looking at 1C2A, I think that's what the minister just
Sure.
Explained.
Right.
There's no comment on that?
No.
Okay, so the minister, we're now going on to the B,
B part.
and I believe that's where Caroni East has a question.
Yeah. Well, you can explain why
so
you moved it from sale
that's
to...
why I said, Minister, we're going on to Clause, to the amendment at B. Yeah.
Table today, I'm assuming this is the correct version of the bill. And this says resale, but the AG has one that says sale.
Yes, Minister, the report was not there.
Updated one that is not before us.
You don't know how that, you don't know where this came from?
That's what I said.
Okay. This doesn't have the correct schedule.
So it appears to have a self-correction.
Doesn't have the correct schedule.
So we could abandon CD.
All right, could we just double check and see what bill?
So, Madam Chair, we're just on the point of making sure that in Clause 2, subclause 1C Roman 2, that the definition of trading business has the word resale in it.
Yes.
Mine has resale.
Yours has sale,
Yes.
as did mine.
Yes,
Correct.
So you're changing it?
What has happened is that on our desk today, we received a copy of what appeared to be a bill which has the word resale in it. So I don't know where that came from. So I want to make sure that what is before us on second reading has the word sale in it and not resale.
So,
Keep it handy. That's a bill that has resale.
Substitute would be sale.
It doesn't incorporate all the...
yeah, in your amendments, Minister, you have...
Okay, so I'm not sure which one the Minister of Finance has, but the one that has just been passed to me doesn't have resale. That's where resale will go, where the arrow is.
Definition of
Madam
trading
Chair.
business.
1 minute, please, Karenese. Let's just make sure what we are all doing here.
See, in the petroleum production levy and subsidy, it has to do
It's the same thing.
But that's not where we are.
Okay.
Yeah, the
We
question of
are
sale and
close.
resale.
Okay. So let's,
So 2(1)C Roman 2. Resale is the correct one. So pilot the
So it
amendment.
was correct in one place,
Yes.
not correct in another
Yes,
place.
yes.
Yeah, yeah, okay.
okay, so just let the Minister present what the amendment is, and then I'll call upon you, Member for Carney.
Sure.
Central, East, sorry.
It was necessary to use the word resale because you're purchasing it and you're reselling it. Simple as that.
So what you have in the amendment here is what you really want to do.
Yes.
Substitute the word resale.
For sale.
Because
No.
you're purchasing and reselling.
Substitute the word sale by the word resale.
Yeah. Remove sale and substitute it with resale.
Because you are reselling.
Correct.
Okay. All right, fine. You explained it. I'm a great appreciate
No,
that.
I'm all right. I don't know what them quarreling about.
No, but you had some confusion about one bill and another bill.
Look at this one. You want to
All right, Minister,
Yes,
could
ma'am.
you present your
Certainly.
following amendment to subclause 2?
Okay, in D, in the Amendment D, we are inserting the correct fifth schedule now. There was a printing error with the fifth schedule. And it's self-explanatory, but
So,
I don't know what sort of explanation members would want.
okay, so just for clarification, there is here a fifth schedule marked Appendix A. Are you deleting that in its entirety? Or is what you're now proposing going ahead of it? All right,
Madam Chair, it goes ahead.
all right. And therefore Appendix A remains?
Yes, Madam
Yes.
Chair. So what happened is that in the formatting that the printing engaged in, what was sent to the Parliament omitted a section which should be in the schedule. So the material which is circulated in this amendment is inserted into what appears into the bill. It goes ahead of it. It goes between fifth schedule and Appendix E.
Web?
Yeah, Madam Chair, I just want to put on the record that this insertion of this schedule before Appendix A is a major schedule. And we didn't get a chance at all, I just put it in on the record, during the debate, to debate this critical schedule because it have a set of formulas, numbers that, you know, I guess we'll have to deal with that in the Senate.
Madam Chair, if we could address that.
Yeah.
The reflection upon these amendments is really a technocratic reflection. So the price points established for petroleum products, Trinidad and Tobago positions.
Excuse me, I think we all need clarification, so I just ask if maybe we could hear the Attorney General so that the discussion could be facilitated. Attorney General.
So, Madam Chair, if we look at what is being inserted into the fifth schedule, the fifth schedule as printed would not make sense. It just starts with Appendix A and Appendix B. Appendices must come, obviously, on the back of a structure from which they are referred. What we are inserting here is the very rubric of the ex-terminal price, which is the first point that we put in. We then say what the formula for arriving at that price is going to be. We then state what the rate of exchange will be, the price of last preceding day to be taken into account, the wholesale price of petroleum products, the retail price of petroleum products, the retail price of petroleum products as referred to in Appendix A and Appendix B. So it is only with this formula that it makes sense. The input of members into this is really something which can have no effect in a debate, and I'll say that respectfully this way, because this is derived by a technocratic examination by the experts in the Ministry of Energy, who would therefore have the price points for unleaded premium gasoline, unleaded super gasoline, etc., as set out in the schedule. So It is something which we are accepting by way of the technocratic advice coming from the industry experts. Very importantly, it results in achieving what the Minister of Finance undertook to the country, which is that the price would be managed in a particular way. And this is therefore certification of that price.
Yeah. Attorney General, we hear you, and we are hearing your rationale. And bringing a long list of new things onto the schedule. We're having a new 5th schedule, which is very detailed with a number of points. And you are asking us to accept it because the people who are doing the calculations, we might not be able to understand their methodology for calculations. But I beg to differ, Attorney General. We might have been in a position to seek assistance from experts in guiding us whether this is acceptable or not acceptable. So you were saying that we might not be able to understand that, so that's why you allowing this to go on, because your technocrats are saying this is the way to calculate it.
All right.
But we may have differed from it if we had...
Member for Carinese, I have a suggestion.
Yes, go ahead.
I have a suggestion. Let's go through them one by one, okay?
Well, no. I am saying I am not in a position
I know,
to
so
understand
let us try
but
to...
I might have been able to get some appreciation
Madam
from
Chairman,
a technocrat
allow
myself.
me to go through each part of the amendment to clause
I think
2
you understand what it is.
and explain each part, okay?
I think that may assist us greatly.
Okay. So in D, the ex-terminal price of each of the petroleum products set out in this schedule is determined by the application of market prices and inclusion of relevant duties, fees, and costs. Now, the market prices are given in the Appendix A in the original bill. And as you will see, they are all either U.S. Gulf Coast prices or Caribbean cargoes prices. So that you, in order to work out the ex-terminal price, you take the market price, which is U.S. Gulf Coast waterborne, UNL 89, UNL 87, U.S. Gulf Coast waterborne, Jet Kero 54, Caribbean cargoes number 6, 2%, etc. That's the market price. And you add on relevant duties, which would be import duties and so on, fees and costs, which would be the cost charged by Pariah Trading to import, store, handle, distribute the fuel. So that is the meaning of 1.1 after the big D on the first page. As we move over to the next page now, Madam Speaker, 2 of D, when the price of a petroleum product is in United States currency per U.S. gallon, it shall be multiplied by 0.26417 in order to arrive at the price per liter. And what that means is that, as we all know, or should know, as we all should know, that there are approximately 4 liters in a gallon. And the price in the United States is posted in gallons, because the United States is not a metric country. So that you have to take the United States price, U.S. Gulf Coast and so on, and multiply it by 0.26417, which is the international conversion from U.S. gallons to liters, to get the price in liters. I'll just go into one by one, okay? Some of them are self-explanatory, some of them may need a little more work. 3, when converting from United States currency to Trinidad and Tobago currency, the rate of exchange shall be the average of the commercial bank selling rate quoted by the central bank and sight drafts on New York for the corresponding calendar month. And this is simply to set the rate of exchange, because again, we're buying fuel in US dollars. So there must be a conversion. We're selling fuel in TT dollars at the pump and also wholesale to NP and Unipet. So you have to convert from US to Trinidad and Tobago dollars for the price at the pump, and therefore you must have a reference. And the reference that's being used here is the average of the bank rate in Trinidad, as quoted by the central bank on a daily basis, and the rate for sight drafts on New York for the corresponding month.
But the last line said for the corresponding calendar month. But let's say you're buying on the 10th of February. How are you calculating the average for the corresponding month of February?
I'm going to tell you.
Yeah.
The rate of exchanges at the commercial banks is quoted on a daily basis. Okay? So in Trinidad and Tobago, if you go on Central Bank website every day, you will see a rate of conversion from US dollars to TT dollars. If you go on Royal Bank website, you go on Republic Bank website, you go on FCB website, you will get a rate of conversion from US dollars to TT dollars.
But my issue, Minister.
I'm not finished.
All right.
But the site drafts are posted on a monthly basis. So you're taking a monthly rate and you're averaging it out with a daily rate to get the actual rate on the day itself. So the site draft rate will not change for the entire month, but the commercial bank selling rate will change every day.
Can you explain the site draft for the corresponding month is determined at the beginning of the month or when?
It's in the month. It's determined in the month. Yes, beginning of the month.
The beginning of the
Yeah,
month?
beginning of the month.
Because if you say any part of the month, it would
No,
be
beginning of the month.
Well, it's there for the corresponding
For the
month.
it's for the month. Okay? So let's say the 10th of February,
Yeah.
it would be the site draft rate for the month of February, which will be posted on the 1st of February.
Okay.
Okay? In New York. All right? So let's move on now to item 4. If on account of Sundays, holidays, or any other reason, the price of any of the petroleum products set out of this schedule or the rate of exchange is not ascertainable for any day, then the price or rate of exchange for the last preceding day for which such price or rate of exchange is ascertainable shall be used. Now, I don't know if you are aware, but the conversion rate for US dollars to TT dollars is posted Monday to Friday. It is not posted on a Saturday and Sunday. However, the site draft rate will run for the whole month. So if they're dealing with this product on a Sunday, for example, they will have to use the Friday rate for the conversion, but the site draft rate in New York will remain the same. Okay? Right. So let's go now to 2. The wholesale price of petroleum products listed hereunder is as follows. And you go through the actual ones. Unleaded premium gasoline, 95 RON, exclusive of VAT, 489 cents, 0.111, inclusive of VAT, 550, 250. Unleaded super gasoline, 92 RON, and that's really premium and super, 419.778 cents, 472.25 cents when you add VAT. Unleaded regular, well, we don't produce that at this time. Hopefully when the refinery operations resume, we can have a supply of regular gasoline again. So we take in front, as it were, using the local parlance, 211.611 cents, not inclusive of VAT, 238.062 VAT inclusive. Domestic kerosene, 118.333 cents, 133.125 VAT inclusive. And auto diesel, 286.111 without VAT, and 321.875 with VAT. And this is wholesale price. There's a difference between wholesale and retail.
Madam Chair, can I ask the Minister?
Sure.
Is the wholesale price of purchase or resale?
Sale to Unipet and NP.
So it's the resale price?
It's a sale, well, all right, resale, yes, because we have changed sale to
resale
resale. Quite correct. Okay?
Thank you.
And now you come to what you will see at the pump, which is in 3, where you now have what the consumer buys at the pump. And let me use the VAT inclusive prices, 575 cents or $5.75 per liter of premium, 497 cents or $4.97 per liter of super, $2.60 per liter of regular when it is available again, $1.50 per liter of domestic kerosene, and $3.41 of auto diesel. These are now the retail prices that the consumer pays in the gas station. Okay?
Can I?
Yeah, sure.
So in other words...
Just a minute. So I'll take Caroni East and then I'll take Pointe-a-Pierre.
Okay.
Minister, so the wholesale price you're quoting here to sell to Unipet and to NP.
Yeah.
Let's say unleaded premium is 489.111, but at the pump is 511.111. So these
You use the
companies-
VAT inclusive price.
Yeah.
Yeah.
So these companies will be making a little...
A margin.
A margin.
Yeah.
From 489 to 511. About
Well,
22 cents
if you
above
use the VAT inclusive price, it's easier that way.
25 cents.
550 for premium wholesale and 575 for premium retail. So they make 25 cents. Okay?
Yeah, well, I'm glad this has come on because the general population wants to know
It's all right.
what they're buying at and what they're selling at. And I
Okay.
think this is
I'm
important.
glad that you are glad.
Member for Point of Peer?
Minister, I notice aviation prices are not here. Is there a reason, or is it in another schedule somewhere?
We haven't received any information on that, but I can tell you what the reason most likely is. We did not produce aviation fuel. It was always imported.
Well,
but I will double check that. Okay?
But now that it be imported through barrier.
Well, you don't need to. You don't need to do anything because
Are you saying
we
that
produce aviation fuel at
we
a
never
point of
produce
time.
aviation? Sorry.
1 minute, please. Member for
I can't answer that.
Member, I'll
I
take
don't
member
think
for
we produce
Tabaki
aviation.
and then member for Shogunas. The same question?
No, it's important in this discussion.
Okay.
I just, oh, sorry.
So, member for Point of Peer, you completed?
Well, I think
Oh, you can.
Shogunas
Member for
will continue.
Shogunas East.
I just wanted a confirmation what you said, that we did not produce.
Listen, I'm not going to state that definitively, but you also have to realize that this is all for the purpose of determining the subsidy, because what we're doing is we're amending the Petroleum Act and we're amending Petroleum Production Levy and Subsidy Act, and the purpose of these definitions and the schedule is to determine what the subsidy is, because the price that the consumer will pay for diesel is $3.41, super $4.97, but I'm not aware that aviation fuel is subsidized. You follow? Yeah, market price. Yeah, I'm not disputing that. Yeah, I'm not disputing that. But I'm fairly certain it's not subsidized. So there's no requirement to have a formula to work out what the price of aviation fuel.
Is that why it's not there?
I can only assume so.
Yeah.
But I will get clarity.
No,
that.
there's the reason. That's
I'll
correct.
get clarity on that.
So,
You see, this has come from the Ministry of Energy, and it seems logical that that's the reason why it's not here. Okay?
member for Tabaki, do you still have a question?
No, it was taken up by...
Okay. Member for Caroni East. Member for Shogunas East.
What is it?
Member for Point of Peer. Member for Baratari Sanwan. Okay. So, Minister of Finance.
Well, there's one more thing.
Yes.
The margin we are giving the reseller, let's use that as a term, is 8 cents. So Paria Trading gets 8 cents for every liter that it buys and sells. Okay? So that's the purpose of 4, and they would sell the items in Appendix A, and they will get, if you look at the last paragraph of the last page of the list of amendments, she shall be at the price equal to the external price plus the sum specified in Appendix B for each product. They get an 8-cent margin on each one. So that's what we're paying Paria for the fuel that it distributes to NP and Unipet. 8 cents per liter.
Member for Shogunas East.
It's just semantic, really. I just wanted to get an idea. Item number 4, where you had the retail price of the petroleum products listed in Appendix A and sold by a person. Is that what is it normally used in that jargon, or is it an entity? So that doesn't have to be a person, or unless you are
A person is
describing
a
a company,
term
it could
of-
be
a person. It's a term of law. Corporate. You can have a corporate person.
Yeah,
Yeah,
okay.
yeah.
So is that? I just want to know whether
Yeah, it
acceptable.
means, it means corporation.
It covers, right?
Yeah. Okay.
Member for Point of Peer.
Minister, if you go back to the first page D, XML price in brackets 28/1987. Why is that a date, or could you just?
That would be
Because there's a new
amended.
schedule, there's a new schedule included. Why is there?
28 of 1987.
That is what was there. They use these marginal notes from the existing schedule.
It is the marginal note in the existing schedule in the, it can come out if necessary. No need to have it.
But
You wanna take it
they're
out?
useful in terms of reference because when you're going back in law to trace things, it helps you to find things. So I'd recommend that it stays.
In the existing act.
Yeah.
If you look at the existing act, at the side,
The marginal note.
on the right-hand side, they will tell you all the years when amendments were made to this particular schedule. So this was the 28th such thing in 1987. Okay? 28th such order, I assume?
Yes.
It will be an order, right? So it's order number 28 of 1987. So it's just, as the AG has said, it is helpful for research purposes to leave it in. Okay?
Completed?
And certainly I will get the clarity on the aviation fuel, but I'm pretty sure that's what it is. There's no subsidy on aviation fuel, okay? Because we sell it to foreign airlines. Not, it's used, it's taken away from Trinidad and Tobago, so you don't want to subsidize a foreign airline.
Caribbean Airlines used to get a subsidy.
That's different. No, they don't get it at the pump. They get it by agreement, by an arrangement with the Ministry of Finance. So they pay for the fuel at the world market price, and then they apply it to the Ministry of Finance. But that's only under certain conditions when oil price reaches a certain level. Okay? You wanted to say something?
My understanding is that aviation fuel is run 80 to 87 octane. I'm looking here.
Okay.
We used to sell that as regular long ago, but since it's no longer in the local market and it's in the aviation fuel, and therefore there's no fixed price. No.
So it fluctuates,
it fluctuates
with the world market price.
And therefore
so there's no subsidy.
You're correct.
So there's no need to put it here. Thank you very much for that clarification. All right, so we all clear now? The reason why... No, I'm not arguing. I'm glad for the help.
I guess what this shows is that we recognize the value.
I'm glad for the help.
Madam Chair, I recognize that value from
I'm glad for the help.
What? I'm
You're not taking it from him?
I'm amazed.
I'm scared, actually.
Genuinely amazed.
Okay, Minister of Finance, have we dealt with all the amendments?
I believe so. We have to go back to the front.
Yes, no. Are we still under clause 2?
Oh, no.
Have you presented all your amendments under clause 2? That's what I'm asking.
I believe so. Yes, Madam
Have you
Speaker.
turned the page?
Yes, Madam Speaker.
Okay.
I reached the end.
Member for no, we haven't reached this yet. We still are close to. Okay. All right. So the question is that clause 2 be amended as circulated. Those in favor say aye. Aye. Those against say no. I think the ayes have it. The question is that clause 2 as amended now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 3. The question is that clause 3 stand part of the bill. The question is that clause 3 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 3 now stands part of the bill. Clause 4. The question is that clause 4 now. The question is that clause 4 stand part of the bill. Minister of Finance.
We are taking out clause 4 because we want to revisit what we're doing to the Income Tax Act, and in any event, we have that act in a committee, which actually sat today. So I would just like to leave that alone for the time being.
All right, I believe member for Carney, you have a question? He didn't. Member for Carney didn't hear.
Why are you deleting it?
To leave the law as it stands.
Let's just leave it as the law as it exists at this point in time.
Why? Why you didn't want to change it?
Madam Chair, if I could assist. Members will recall that we amended the Income Tax Act to turn the key of the Global Forum. We're awaiting on the confirmation of the Global Forum to come back. What we then did was we referred the clauses which were not supported by the opposition to a Joint Select Committee to meet the other Global Forum bills. So what we want to do is to just settle exactly what's going on in that arrangement. When we have that, we can consider it in the round. Today we had the first meeting of the Joint Select Committee to consider that particular bill, so we can deal with it as a whole unit.
So this will, This will
So if we have need to
occur
come back and
subsequent
treat
to
with
that.
this, we can deal with it there.
Subsequent to that
Yeah.
deliberation.
Yeah.
Within that session, I can't talk too much because it's in a committee, but the bills have been referred, so it's public knowledge, is an amendment to the Income Tax Act.
All right. So we'll have to await that deliberation.
Yes. We don't want to interfere with it now. Let's finish our business, and then we'll deal with a holistic approach to the Income Tax Act.
So that will change clause 1 as well.
Clause 1?
Which is why we've deferred it.
Yeah.
Yeah.
Right.
It changes the title.
Yeah.
Correct.
So this is now only a bill dealing with petroleum production levy, which is really what it should have been.
And you're leaving out the income tax.
Yeah. It really sneaked in there. Okay, so we're taking it back out.
The question is that clause 4 be amended as circulated. Those in favor say aye.
Aye.
Those against say no. I think the ayes have it. The question is that clause 4 be deleted from the bill. Those in favor say aye.
Aye.
Those against say no. I think the ayes have it. We now revert to clause 1. The question is that clause 1 stand part of the bill. Minister of Finance.
Yes, Madam Chairman, I would like to propose the amendment as circulated where we are changing the title and by deleting the clause, substituting another one. And the only difference is that the words "and income tax" come out. So this bill will now just be dealing with petroleum and petroleum production levy and subsidy. That's it.
The question is that clause 1 be amended as circulated. Those in favor say aye.
Aye.
Those against say no. I think the ayes have it. The question is that clause 1 as amended now stand part of the bill. Those in favor say aye.
Aye.
Those against say no. I think the ayes have it. Honorable members, due to the amendments that have been made to the bill, the title of the bill has to be amended to read as follows. An act to amend the Petroleum Act, Chapter 6201, and the Petroleum Production Levy and Subsidy Act, Chapter 6202. Honorable members, the question is that the bill... Honorable members, the question is that the bill as amended be now reported to the House. Those in favor say aye.
Aye.
Those against say no. I think the ayes have it. This committee meeting is now adjourned. The House will resume. The Minister of Finance.
Thank you, Madam Speaker. I wish to report that a bill entitled, that the bill, an act to amend the Petroleum Act, Chapter 6201, the Petroleum Production Levy and Subsidy Act, Chapter 6202, and the Income Tax Act.
Okay.
Sorry, I'm reading the wrong thing.
Yes.
I'm terribly sorry. An act to amend. No, that's not the bill.
Remember, we amended it a long time.
No, it's all right. No, I'm good. Madam Speaker, that an act to amend the Petroleum Act, Chapter 6201, the Petroleum Production Levy and Subsidy Act, Chapter 6202, and the Income Tax Act, Chapter 7501, Bill 2019, was considered in Committee of the Whole and approved with amendments. I specially report that the title of the bill was amended to read an act to amend the Petroleum Act, Chapter 6201, and the Petroleum Production Levy and Subsidy Act, Chapter 6202. I now beg to move that the House agree with the committee's report.
What happened?
Honorable members, the question is that this House agree with the committee's report on the miscellaneous provisions, petroleum production levy and subsidy bill 2019. All in favor say aye. Aye. Any against? The ayes have it. Minister of Finance.
Thank you, Madam Speaker. Do I have to say anything else? Attorney General, it's all right, it's all right. Madam Speaker, I beg to move that an act entitled an act to amend the Petroleum Act Chapter 6201 and the Petroleum Production Levy and Subsidy Act Chapter 6202 be forthwith read a third time and passed.
Honorable members, the question is that a bill entitled an act to amend the Petroleum Act Chapter 6201 and the Petroleum Production Levy and Subsidy Act Chapter 6202 be forthwith read a third time and passed. All in favor say aye. Aye. Any against? I think the ayes have it.
A bill entitled an act to amend the Petroleum Act, Chapter 6201, and the Petroleum Production and Levy and Subsidy Act, Chapter 6202.
Leader of the House.
Madam Speaker, I beg to move that this House do now adjourn to Monday, the 10th day of June 2019 at 1:30 p.m. Madam Speaker, on that day we'll be doing the miscellaneous provisions, financial institutions, securities and insurance bill 2019, the miscellaneous provisions, tax amnesty, pensions, freedom of information, national insurance, central bank, and non-profit organizations bill 2019, and we will also be doing the amendments that were circulated today from the Senate, that came from the Senate, Madam Speaker.
Nice.
Honorable members, there's one matter that qualifies to be raised on the motion for the adjournment of the House.
Madam Speaker, by agreement, that matter will be deferred until Monday.
Whip. Okay, thank you. Honorable members, the question is that this House do now adjourn to Monday, the 10th of June, 2019 at 1:30 p.m. All in favor say aye. Aye. Any against? The ayes have it. This House now do stand adjourned to Monday, the 10th of June, 2019 at 1:30. It is so refreshing after a long day for us to end in such a congenial mood. This House now do stand adjourned to Monday, the 10th of June, 2019 at 1:30 p.m.